Welcome back into Eye on Agriculture. I'm Britton Rucker. We are in part two of a look back at the most important developments in agricultural law and tax from 2023. We're joined now with Roger McEowen, professor of agricultural law and taxation at Washburn University, to walk us through some of these. As always, Roger, pleasure talking with you today.
Well, thanks for having me, Britton.
All right, to kick off the discussion, the scope of the dealer trust, a huge topic for 2023.
Yeah, Britton, this was an amendment to the Packers and Stockyards Act that was done in late 2020. And what it does is create what's called a dealer's trust with the intent of giving some protection, financial protection, to unpaid cash sellers of livestock, to certain types of covered feed yards and market dealers and so forth. And what we had in 2023 was a series of cases that have been filed that are going to test the scope of what's in that trust and what is protected. There were several feed yards that got involved in a massive Ponzi scheme. They misreported or failed to report the sale of about 78,000 head of cattle. There's a major ag lender that's involved in this. And during 2024, hopefully the legal system will sort out for us what the provisions in the statute actually mean.
Now, equity theft, another big one for producers.
Yeah, that was a case that went all the way to the U.S. Supreme Court, and it was a unanimous opinion of the court. And what happened was a homeowner in the Minneapolis-St. Paul area got behind on property taxes, completely defaulted, and the county came in pursuant to state law and sold the home at a foreclosure sale and kept all of the proceeds. More than just what the tax debt was. They kept her equity in the property. And the U.S. Supreme Court said, no, you can't do that. It's a take the Fifth Amendment. And the problem, Britton, is that there are 12 states that have statutes like that allow the state to keep the equity, and they're going to have to retool their statutes. There was a farm in Massachusetts, an alpaca farm that this happened to, as well as a ranch in Nebraska. And now the Supreme Court has straightened that out.
Is Kansas one of those states?
No, Kansas is not.
All right, very good. And moving on, the basis of assets contained in an intentionally defective grantor trust. If you don't speak lawyer like I do, break this down for us.
Yeah, some are probably wondering, why in the world would I want a defective trust to begin with? Well, it's defective from an income tax standpoint, meaning even though I've transferred all of my property into the trust and I keep it out of my estate for estate tax purposes, so it's effective for estate tax purposes. If it generates income, I'm going to pay the income tax on that. So it's defective from an income tax standpoint because I'm still stuck with the tax burden. Well, why would I want to do that? So that a property that appreciates, generates income, my beneficiaries and heirs of that trust don't have to pay the tax on that. So it builds up wealth tax-free for the next generation. Great wealth transfer planning technique for farmers and ranchers in the right situation. The question has been, even though I transfer that property away from me, my retained power to pay income tax, is that enough to allow that property to get a stepped-up basis equal to the fair market value at the time I die in the hands of my heirs? The IRS waffled on this for many years, but in 23 they said no basis increase.
Interesting. Well, Roger, we'll check back in with you over the next couple of weeks. Like you said, we haven't even gotten to top 10 yet. So we'll be working through some of the biggest developments of last year in ag law and tax. Roger, thanks again for coming on, and we'll see you next week. Everyone stick around. Eye on Ag will be back after the break.